I am live. All right. Sorry. I didn't give any advanced warning because I'm just also assuming with how early I'm going on and stuff, people wouldn't be able to make it. So I just wanted to do this live video and give you all the update. So, Jax West from Justice with Jax, Stephen Avery Project, MAM Gossip. Today I went to court for Marni Yang. This has been a long time coming, but the judge agreed today for a stage 3 evidentiary hearing. Yay! Um so court itself was really quick, like 5-10 minutes. It was, and Marnie was brought up from prison, 4-hour drive. The judge just right away says he's got his order, his ruling, whatever they call it. And so a copy was going to Marnie's attorney, Judd Stone. A copy was going to the prosecutors and said, all right, let's set a date, which is, it's more money, more time. Setting a date for a week from now for just them to discuss and come up with what date the evidentiary hearing will start. So the in a week and a week and a half or whatever, when they're meeting for that, Marnie doesn't get brought up for that. It's just them now. Everybody looking at their schedules because like Jed Stone's got another murder trial that he's on. So what fits in that they will start this evidentiary hearing? So it could be months. They could be saying it's not going to start until September. I don't know, but this is really good news that we're getting to finally move to that. And I literally just got the court documents right now. So I'm going to read that. It's 33 pages long. Order. This matter comes before the court on the state's motion to dismiss certain claims from defendant Marni Yang's petition for post-conviction relief filed pursuant to the Post-Conviction Hearing Act. Having reviewed the record, statutory authority, and case law, the court now finds and orders as follows. Background. On October 4, 2007, Ronnie Ryder, who was 7 months pregnant, was shot and killed in Ryder's second floor condominium in Deerfield, Illinois. At the time of her death, Ryder had been in a 17-year relationship with the father of her baby, former Chicago Bears football player Sean Gale. Gale's relationship with Ryder was not exclusive. Gale testified that his numerous romantic partners included defendant, who he met at a 2005 Chicago Bear convention. According to Gale, at some point, defendant became frustrated with the non-exclusive nature of their relationship. In the summer of 2007, Gale told defendant that he was going to be a father. At about 7:50 a.m. on October 4, 2007, Ryder's neighbor, Manda Cameron Hussein, saw a person between 5 feet and 5 feet 5 inches tall, wearing a baggy tracksuit, face paint, and a wig. You don't know that. Um, um, Entering Ryder's building in Deerfield. A few minutes later, just before 8 a.m., Ryder's neighbor in the unit directly below heard a short scream, quote, a kind of plop. This says plop, plop, but every time I've heard it, to me it sounds like she's saying pop, pop, not plop, plop. A kind of plop, plop, unquote, that did not sound like a gunshot, and a, quote, humongous, unquote, crash, which sounded like pots and pans hitting the floor. No pots and pans hit the floor, so I don't know why it would sound like that either. This neighbor called the police. A third neighbor, Peter Cowles, testified that just prior to 8 a.m. on the morning of the murder, he witnessed a black boy about 12 to 14 years of age with his hair piled up and pinned on top of his head, running across the parking lot and getting into the driver's side of a car. Cowles thought he was a schoolboy and was surprised when he got into the driver's seat because Cowles thought he was too young to drive. Paramedics found Ryder lying face down on her kitchen floor in a large pool of blood, unable to be revived. She had been wounded 7 times. The immediate cause of death was a single bullet wound to the back of Ryder's head. 2 bullets struck Ryder's abdomen, killing the unborn child. Ryder also had 2 bullet wounds in her arms, which, according to the pathologist, occurred when Ryder tried unsuccessfully to shield her abdomen. That's not possible from the science. Spent 9mm casings, as well as 5 unfired rounds of ammunition, surrounded the body. The police initially had 3 suspects: Sean Gale, Monika Karaska, Polish accented Gale dating partner, that's the way they've worded it, and Marni Yang. While Karaska, sorry, I have a hard time pronouncing that, had demonstrated unusual emotional behavior in her relationship with Gale, she had an alibi the time of the murder. Police spoke with Gale for 10 hours in the hours after the shooting. They also interviewed Gale's various associates and followed up on their statements. Gale did not have an alibi until after 9 a.m. the morning of the shooting, when he left his home to get a haircut. Gale testified that his ability to run had been limited because he had been in a motorcycle accident a few weeks prior to the murders. When police began investigating defendant, Gale cooperated with police and agreed to wear a body wire to record his conversations with her. Defendant said nothing incriminating to Gale. Information from defendant's friend, Julie Fields, a few days after the murder, led police to focus their attention on defendant. Fields testified that defendant repeatedly accessed Gale's email account. She once used it to cancel hotel reservations Gale had for a trip to Europe with Ryder. Additionally, defendant learned that Gale was seeing Monika Karaska. Fields testified that defendant bragged that she used Karaska's name and imitated Karaska's style of broken English to send threatening emails to other women involved with Gale. Defendant asked Fields to call the fiancé of another woman Gale was seeing, but Fields declined. Fields testified that defendant knew of Ryder's relationship with Gale, Ryder's occupation, and where she lived. A search of defendant's work computer showed defendant had obtained driving directions from her work to Ryder's home address. Defendant's co-worker, Maggie Zimmer, testified that defendant talked about Gale on a daily basis. According to Zimmer, defendant confided that she had obtained access to Gale's email account, and defendant often complained about Gale's emails from other women, critiquing their style and content. Like Fields and Zimmer, defendant's teenage daughter, Emily Yang, testified that her mother had gained access to Gale's email account and learned that he was seeing other women. According to Emily, defendant told Emily that she sent letters to the other woman Gale was dating. Defendant's bank statement showed that she had paid for dozens of online background checks for personal information regarding the women with whom Gale was involved. A search of defendant's home revealed several typed but unsent letters describing Gale's multiple long-term relationships with women all over the world. Defendant's home office also contained several address labels and return labels. The address labels matched the addresses defendant had received from the background check company. The return labels bore Gale's name and address. After Ryder's death, police discovered an unsigned typed letter in broken English with a warning about, quote, what your boyfriend is doing, unquote, inside her purse. The author of the letter claimed to have, quote, found out everything, unquote, about Gale's long-term relationships with multiple women all over the world. The letter specifically referenced Ryder's history with Gail. The author listed the names and phone numbers of 16 other women, including defendant, and told the reader to contact these women, quote, so you can see for yourself, unquote. The letter was nearly identical to the unsent letters found in defendant's home. Christy Passion, friend for 20 years, testified that defendant spoke with her about accessing Gail's email. Further, in the summer of 2007, defendant told Passion that she was frustrated that Gail continued to see other women and that she was going to kill him. Defendant told Passion that Gail was incapable of being a parent and did not deserve a child. According to Passion, at some point, defendant began to contemplate killing Ryder instead of Gail. Passion testified that defendant said she had once gone to Ryder's apartment building with a gun, but she changed her mind at the last minute about shooting Ryder and left. Defendant owned a black 9mm Beretta handgun with fake pearl grips. Shooting range owner Don Mastriani confirmed that defendant used a Beretta 9mm handgun at his facility. Mastriani also purchased 9mm ammunition from Mastriani. Police did not find defendant's 9mm handgun in any of their searches after the murder. Police obtained evidence showing that defendant made or attempted to make a silencer. August 2007 bank statement showed that defendant used her debit card to purchase a 2-volume set entitled How to Make Disposable Silencers. When the package containing the books arrived at defendant's home, defendant signed for it. Defendant then went to Home Depot and purchased the items needed to build a disposable silencer. These items included a keyhole saw, a hacksaw, rubber cups, duct tape, electrical tape, a marker, a file, a folding razor, piping, and a 1-inch metal hose clamp. When the police searched defendant's home pursuant to a warrant, they found materials consistent with the manufacturer of a disposable silencer. On October 2, 2007, 2 days before the murder, defendant rented a blue car using her own driver's license and a credit card jointly held by defendant's father and a former boyfriend. Defendant exchanged the blue car the next day for a black 2008 Volkswagen Rabbit. Upon its return, the odometer on the black car showed it had traveled 40.2 miles. This mileage equaled the distance from the rental company to her friend Christy Passion's apartment, Passion's apartment to Ryder's condominium and back, then from Passion's apartment back to the rental company. A security camera from a nearby Shell gas station recorded a black hatchback with taillights similar to a Volkswagen Rabbit heading toward Ryder's residence at 7:04 a.m. and leaving the area at 7:55 a.m. There's so much wrong right there. Defendant's friend Passion testified that on October 3, 2007, the night before Ryder's murder, defendant arrived at Passion's apartment about 9:30 p.m. and stayed overnight. At that time, defendant told Passion that if she killed Ryder, she would call Passion on the phone and ask Passion to dinner. Passion did not take defendant's plan seriously enough to call the police. When Passion woke the next morning, defendant was gone. Passion then testified that around 9 a.m. on the morning of the murder, defendant called her at work using a number that she did not recognize. Defendant asked Passion, "Do you want to go to dinner?" Passion testified that on the evening of the murder, defendant told her how defendant had murdered Ryder. Defendant described wearing dark makeup to change her skin color, a black wig, and a hooded sweatshirt with the hood pulled up during the murder. She drove the black rental car from Passion's residence to Ryder's apartment building. Defendant entered the hallway of Ryder's apartment building and, when Ryder opened her door, began shooting. As Ryder retreated and tried to close the door, defendant followed her into the apartment. Before she left, defendant took items from Ryder's kitchen, including a medical bracelet. Yet there's no evidence whatsoever that Marni was ever in that apartment. Passion further testified that defendant told Passion that she planned to place the gun in a bucket of cement and bury it. Passion testified that she and defendant drove around Arlington Heights that evening to discard items from the murder in various dumpsters. Passion saw defendant dispose of several items, including packaging for gun grips, a black wig, and clothes. Passion also saw defendant bury a small object outside of a banquet hall. The police subsequently dug up a distinctive pearl medical alert bracelet that said pregnant in the area that Passion had indicated. At trial, a witness identified the discovered bracelet as belonging to Ryder. So, I don't want to keep interrupting this and going into all of this on why this stuff is not true. But I just have to say about this part, what would be the point of taking the medical alert bracelet to then just get rid of it? If you're taking the medical alert bracelet, it's because you're a psycho and you wanted a keepsake of your crime. So why would you take it to then just bury it someplace? That makes zero sense. And Marni is not an imbecile. Marni would not do that. And also, this bracelet was so freaking ugly. Ronnie would not have worn this fake pearl medical alert bracelet. It's so dumb. In late February 2009, more than a year after the murder, Passion agreed to cooperate with the police investigation. And why did Christy agree? Because they said it's Marni or you. Passion testified at trial that she was never promised anything in exchange for her cooperation. Yeah, she was told you're going to be charged if you don't. On February 28, 2009, Passion called defendant to tell her about Passion's police interrogation. Passion told defendant, quote, I went over everything with them that I could remember, but they were on and on about this phone, about the car. I don't know what the hell that is. I don't know, so you think about it. I am too fucking tired to think about it, unquote. Defendant replied, quote, all right, we'll start making shit up, unquote. Making shit up. In a subsequent phone call, the two arranged to meet in person at a local restaurant on the evening of March 1, 2009. At the restaurant, Passion, set up with a body wire, recorded the conversation. Defendant stated that while, quote, the police were still running in circles looking for a teenager, unquote, she had encased the gun in a bucket of cement, threw the bucket in a Chicago dumpster, and was confident that the bucket was now buried under, quote, a year and a half's worth of Chicago garbage, unquote. Defendant assured Passion that the police were nowhere near resolving the crime and that if the police, quote, had all their ducks in a row, they'd be at defendant's doorstep with a pair of handcuffs, unquote. The next evening, Passion, wearing a body wire, again met defendant at the restaurant. Defendant discussed renting the black getaway car, which she thought would be inconspicuous. She found or stole a set of license plates for the car. Finally, defendant discussed her cash purchase of a disposable cellular phone, which she used to call Passion the morning of the murder to ask if she would like to, quote, go to dinner, unquote. Defendant brainstormed explanations that would match evidence she believed the police had found. Defendant told Passion, quote, anything of substance that the investigator had to try to get you to talk, he put down on the table in front of you. Car rental agreement. Explain it away. You were having car trouble. You needed to get to work. Your credit card would not. Didn't have enough credit on it to be able to put the $250 deposit that was required. You asked me for my help. I said, sure, no problem. So I ran over at lunchtime. Okay? Unquote. Later in the conversation, defendant said, quote, because the only thing that I'm going to need to fill the blank on is what time the car was returned, which I don't remember. It was pretty much right away. And I think it's that explanation is very simple. You had taken the vehicle the night before to run some errands, but that you didn't need it the next day because you got your car started. So I took the liberty, because you were stuck at work, I took the liberty of getting out to your place and returning the car for you so that you wouldn't be charged for another day. Unquote. During this conversation, defendant and Passion discussed the murder as well. Quote, Passion, the detective said to me, what would you say if I told you we had a piece of evidence that linked you and Marni to the crime scene? Unquote. I looked at him and I said, quote, well, first off, there should there should be there should be anything linking us to the crime scene because we weren't there. Unquote. You dumped the wig. Close quote. Defendant. We dumped everything. Passion. We dumped the plates. We dumped the those that stuff for the gun. I have a memory, you told me. Now maybe I'm wrong. Maybe I'm off the wall. That you said that when you were in there, you kind of like glanced at everything as you stood in the door. That there was stuff on the counter and stuff like that. Is there anything? Did you touch anything? Did you take anything? Somewhere I had the feeling that you told me that you had seen stuff on the counter. Defendant. Nope, I said nothing. It was dark in the kitchen. What happened was I stood outside in the hallway. I stood outside on the carpet in the hallway. She opened up the door to the apartment, okay? I was in. I had a wig on. I had dark sunglasses, this big covering my face. Passion. Wow. Defendant. I had a hoodie on, okay? I had dark makeup on my face and I had gloves on, okay? When she opened up the door, that's when I brought out the gun. And when she saw it, she started screaming, and I just let her have it. I just let her have it. I think I maybe took 2 big steps into the kitchen to make sure she okay, and then I left. Passion. No, see what you defendant. No, it was dark in the kitchen. I couldn't see anything. That's not what I told you. I told you it was dark and I didn't see hardly anything. Passion. Well, okay, you said it was dark. Defendant. It was dark. I didn't touch anything. I took maybe 2 steps and I took Passion. What did you see? Defendant. All I saw was everything was in shadows. The kitchen was dark, okay? In fact, it was so dark, I wasn't even positive that I was making straight shots, okay? Didn't she opened up the door and all she saw was a dark-skinned person with sunglasses holding a gun like this with a hoodie on, okay? And she started screaming. I took the first shot. I remember screaming because at this point, I realized we are now at the point of no return, okay? Any thoughts that we had about turning back, we got to finish this now. And I just started emptying the clip. She went because she had already started to come out of the apartment. She went backwards into the kitchen, fell against a counter with the floor, and it was all in shadows. It was all in shadows. Passion. How was it laid out? Defendant. The kitchen? Passion. Yeah. Defendant. I never got far in there enough to see. Passion. Okay. Defendant. I never got far in there enough to see, okay? And don't forget, I also had the dark glasses on. I took maybe 1 or 2 steps into the kitchen to finish the job. All she was doing was screaming until she went down. And then she went down, she took her foot, and she took 1 good kick at me. Got me in the shin. It was like weak by that time. So, like that. And that was it. I took 1 last shot in the head, finished her off, and I took off. Oh, I had gloves on, closed the door behind me. Her leg was sticking out into the hallway. I had to kick it inside. Then I slammed the door, took off. That was it. Unquote. And let me just tell you, if you see the crime scene photos, it shows that everything that was just said there didn't happen. Okay. In March 2011, following a 2-week trial with over 30 witnesses, a jury found defendant guilty of 2 counts of premeditated first-degree murder for the deaths of both Ronnie Ryder and her unborn child. The trial court imposed concurrent natural life sentences. In January 2013, the 2nd District Appellate Court affirmed the conviction and sentence on direct appeal, People v. Yang, blah, blah, blah. The Illinois Supreme Court denied discretionary review. Defendant filed her initial post-conviction petition in October 2019. In February 2020, the state moved to dismiss all of defendant's claims in their entirety. The court allowed defendant discovery, which was impacted due to the 2020 COVID outbreak and other matters. Both parties amended their pleadings multiple times. Ultimately, the state took the unusual step on 4 of defendant's claims of withdrawing its motion to dismiss and filing an answer. The answered claims concerning DNA found on live rounds of ammunition from the murder scene, claims concerning DNA found on the medical alert bracelet, claims involving witness Jesse Delgado, and claims involving witness Stephen Wade will not be addressed in this order. The state's motion to dismiss continues as to all defendants' remaining post-conviction allegations, and the court will address them accordingly. Analysis. And we're now on page 11 of 33. 1. The standards of review. Oh, wait, I'm not reading. That's all other case stuff. Okay, so now I just go to what talks about Marni's case. Defendant in this case appears to allege claims of ineffective assistance of counsel, prosecutorial misconduct, and actual innocence. Yet defendant's petition and its amendments filed by counsel are a mixture of allegations and innuendo presented without the requisite evidence to satisfy the required elements of her claims. This court has done its best to understand these arguments in support of her claims. It is not the function nor the obligation of this court to act as an advocate and search the record for arguments supporting defendant's claims. Nonetheless, the court will fully examine the petition, the record, and the case law to determine whether defendant's petition can survive the state's motion to dismiss and advance to a 3rd stage hearing. The court initially notes that, with the exception of claims of actual innocence, a post-conviction petition must be filed within 6 months of the date for filing a petition for certiorari or a petition for leave to appeal. Defendant filed her post-conviction petition well after these deadlines in this matter, making her non-actual innocence claims untimely under the Act. Moreover, defendant has failed to present any allegations addressing a lack of culpable negligence for the delay in filing the petition. Thus, defendant's claims not involving actual innocence are time-barred and, for this reason alone, are subject to dismissal. 2. Ineffective assistance of trial counsel. In her petition, defendant contends that her trial counsel was constitutionally ineffective in multiple ways. In order to prevail on an ineffective assistance of counsel claim, the defendant must demonstrate both that her counsel's performance was deficient and that prejudice resulted from that deficiency. Defendant must overcome the strong presumption that counsel acted competently and that the challenged action was the product of sound strategy. The presumption, quote, is a high bar to clear since matters of trial strategy are generally immune from claims of ineffective assistance of counsel, unquote. To put it simply, quote, on issues of trial strategy, defense counsel is certain of the ship, unquote. In addition, a defendant must demonstrate a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Prejudice is not presumed at the 2nd stage of this post-conviction process. A defendant, quote, must show that counsel's deficiency was so serious that it deprived him of a fair trial. A fair trial is in italics, emphasized, unquote. The failure to establish either prong of the Strickland test precludes a finding of ineffective assistance of counsel. Defendant claims, I'm like getting hot flashes and dizzy, so I don't know if this is my diabetes now doing something to me right now. Defendant claims that her trial counsel was ineffective for failing to challenge or investigate specific pieces of evidence at trial. I just got an email from Marni's dad. In Illinois, defendants are required to raise ineffective assistance of counsel claims on direct review if they are apparent on the record. Issues that could have been raised on direct review are deemed procedurally defaulted. Defendants' ineffective assistance of counsel claims rely on evidence wholly within the record. Because these ineffective assistance claims could have been raised on direct appeal, they have been waived and for this reason are subject to dismissal. Turning to the merits, defendant initially alleges that her trial attorneys were overwhelmed and failed to examine all of the voluminous discovery material, instead relying on a small fraction of evidence to defend their client. This claim is wholly refuted by the record. Throughout pretrial process, trial counsel, on the record, acknowledged the receipt of discovery documents and materials, referred to subpoenas they had issued, and complained about delays in obtaining other items. At one point, trial counsel informed the court that their expert was in the process of reviewing 8,000 pages of documents. Trial counsel further informed the court that they received 5 cassette tapes, 7 CDs, autopsy protocols, about 120 pages of documents relating to pending motions, and an additional 2,000 pages of discovery for a total, at that point, of 9,000 pages of discovery. Illinois courts have consistently upheld the dismissal of a post-conviction petition when the record from the original trial proceedings contradicts the defendant's allegations. Because the record in this case clearly demonstrates that trial counsel examined more than a small fraction of discovery, defendant's initial allegation of ineffective assistance is unsupported and must be dismissed. Whatever. Defendant also alleges that trial counsel failed to investigate alternative suspects. Once again, the record positively refutes this allegation. The trial evidence demonstrated that Carrasco had an alibi. The trial evidence also revealed that Gale, a former professional football player, did not match the physical description of the person observed running from Ryder's townhome. That of a schoolboy, 12 to 14 years of age, appearing too young to drive. Moreover, no physical evidence tied Gale to the crime. Despite this evidence, defendant's trial counsel repeatedly informed the court that their theory of defense included other available suspects, such as Carrasco and Gale. Defense counsel also attempted to introduce their evidence of Gale's possible motive to kill Ryder. However, the trial court barred any evidence of Gale's possible motive as being too remote, a ruling challenged and upheld on appeal. Since the record directly contradicts defendant's allegations that defense counsel failed to investigate alternative suspects, this claim of ineffective assistance is unsupported and cannot stand. Defendant next contends that her trial counsel failed to challenge the state's claim that the Shell gas station video recorded defendant's rental car heading toward Ryder's residence before the murder occurred and then again leaving the area afterward. Once again, defendant's allegations failed to accurately reflect the trial record. In his cross-examination of Deerfield police officer Juan Mazarigos, defendant's trial counsel repeatedly questioned Mazarigos' conclusion that the black car in the video was in fact the same model car defendant had rented. And we've got experts that show that it is not that car. In addition, in his closing, defendant's attorney suggested the black cars on the video were actually 2 different cars, and neither was defendant's rented Volkswagen. Again, the trial record positively refutes defendant's contention that the video went unchallenged, making defendant unable to establish this claim for ineffective assistance. Defendant further argues that her post-conviction forensic testing concluded the black car shown in the video was not a 2008 Volkswagen Rabbit. In this ineffective assistance context, this testing merely presents another method, different than what trial counsel chose, for challenging the evidence, which is ineffective. You did nothing other than say that it's this. You didn't do anything to prove that it's that. Presenting an alternate method of pursuing the same strategy that trial counsel actually followed tends to support, not rebut, the strong presumption that the original strategy was sound. Moreover, quote, neither mistakes in strategy nor the fact that another attorney with the benefit of hindsight would have proceeded differently is sufficient to establish ineffective assistance of counsel, unquote. Oh, that's People versus Dobbs. Fuck you, Dobbs. Hi, Bryce. Defendant's reliance on the results of her post-conviction forensic testing fails to establish deficient performance here. Defendant next claims her trial counsel was ineffective for failing to challenge the assertion that defendant made a homemade silencer. With this allegation, defendant again ignores the multiple instances in the record where trial counsel did in fact challenge this assertion. Defendant's trial counsel objected to the admission of testimony regarding the purchase of items used to make a homemade silencer, arguing, quote, there is no evidence of any kind as to what kind of silencer, if any, was ever used or built, unquote. Further, during his cross-examination of the investigating officer, defendant's trial counsel repeatedly questioned whether defendant even made a silencer. Because the trial record affirmatively rebuts this claim of ineffectiveness of trial counsel, dismissal is warranted. To further support this claim, defendant presents her expert's report that a functioning silencer could not be made with the items defendant purchased. Once again, in this ineffective assistance context, the expert's report merely presents an alternate method of pursuing the same strategy. My Alexa downstairs is saying somebody's trying to call my husband. Indeed, during his closing, trial counsel attempted to undermine the state's expert with this exact point. Rather than rebut the strong presumption that trial counsel's strategy was sound, defendant's post-conviction expert supports her trial counsel's strategy and fails to establish deficient performance. Defendant additionally claims that her trial counsel dropped the ball when he mistakenly stated that an email helpful to defendant's alibi originated from her BlackBerry rather than her home computer. Defendant has failed to articulate a cognizable, ineffective assistance of counsel claim here as well. Trial counsel made the statement during proceedings that were held outside the presence of the jury. As a result, this statement has no impact on the jury's verdict and is insufficient to establish deficient performance. Defendant's remaining claims of ineffective assistance of counsel include trial counsel's alleged failure to challenge false statements in the cell tower reports used to support the state's wiretap application, and an alleged failure to challenge missing seconds from the state's telephone recordings. Neither of these conclusory allegations are substantively developed so as to warrant a third stage hearing. Moreover, the record shows that defendant's trial counsel did in fact challenge the state's wiretap application with a motion to suppress. Defendant's trial counsel presented their arguments at an evidentiary hearing before the judge subsequently denied the motion. As the court has previously found, this issue could have been presented on direct review and is therefore waived. Even without waiver, defendant has failed to meet her substantial burden of showing that defendant's trial counsel performed deficiently. Lastly, all of defendant's claims of ineffective assistance contain the same fatal flaw. Defendant fails to allege the required element of prejudice. Prejudice cannot be implied at second stage. A defendant must show that counsel's deficiency was so serious that it deprived him of a fair trial. Defendant has failed to make this showing. Indeed, she has failed to present any argument that, had her trial counsel not performed efficiently, the result of her trial would have been different. I always hate that they do that on anything. You don't know what a jury's going to say regardless if they knew this or that. So for you to assume that a jury wouldn't say otherwise if given this stuff, you don't know that. Just like we don't know that they would say differently. Nobody knows. So therefore, it should go. Right? Everybody, both sides are supposed to be about justice, right? And wanting to get the people, the actual killer or guilty party. So, the state really shouldn't be so desperate to not hear new evidence and to block people from hearing new evidence. Defendant has failed to meet her burden of making a substantial showing of a constitutional violation, and the court finds that all of her claims of ineffective assistance of trial counsel must be dismissed. Section 3, prosecutorial misconduct. Before even reading this, let me just tell you, the person who is the prosecutor in Marni's original trial is now a judge in this very courthouse. So, of course, a judge is gonna protect another judge. So even before me even reading this, there you go. All right. Defendant next alleges that her trial suffered from multiple instances of prosecutorial misconduct. Defendant's allegations fall roughly into two categories: inducing perjury and violations of Brady. Defendant does present one claim of prosecutorial misconduct that is outside these categories. Defendant alleges that the prosecutors presented a wiretap application supported by misleading documentation. As this claim is based solely on facts within the record, it could have been presented on direct appeal and is therefore waived. Further, defendant has not made a complete, substantive, or cohesive argument to this court that a motion to suppress based on the allegedly misleading statements would have been granted, thereby rendering the wiretap evidence inadmissible. In fact, defendant fails to acknowledge that she presented a motion to suppress this wiretap that was heard and denied by the trial judge. As a result, this claim warrants dismissal. Inducing perjury. Defendant initially contends that Lake County Assistant State's Attorney Patricia Fix induced defendant's teenage daughter, Emily Yang, to perjure herself. Emily was at court today, by the way. Any conviction, quote, obtained through the use of false testimony implicates due process concerns and is subject to reversal, unquote. Where the state's case includes perjured testimony, and the state knew, a strict standard of materiality applies. The conviction must be overturned, quote, if there is any reasonable likelihood that the false testimony could have affected the judgment of the jury, unquote. The, quote, strict standard of materiality applies even if the state did not solicit the false testimony, but rather left it to go uncorrected, unquote. According to Emily's notarized affidavit, Emily's trial testimony consisted of lies. In her affidavit, Emily states that before trial, quote, I told Assistant State's Attorney Fix that my written statement was false, and the text of it was given to me by the police who interrogated me. I told ASA Fix that I did not want to lie under oath. ASA Fix angrily told me if I didn't testify to the lies I had written for the police, I would be in big trouble. ASA Fix knew what was in my statement was a lie. She knew that I did not want to continue lying. She did not care about the truth. She coerced me to tell lies at trial, unquote. To begin with, the court observes that the affidavit does not identify with any specificity the lies Emily told during her testimony. nor does defendant reveal the truthful versions of Emily's alleged lies. Even without this information, Emily's affidavit is contradicted by the trial record. The record shows that after Emily provided her written statement to police, but prior to trial, Emily's attorney appeared before the court on a motion to exercise Emily's Fifth Amendment rights. During the hearing on that motion, ASA Fix informed the court that, quote, while Emily has actually been served, Emily has not been willing to speak with us to further flush out a greater foundation for her statement, unquote. Later in the hearing, ASA Fix again informed the court that the state had tried to speak with Emily, but had not actually spoken to her. During trial, immediately prior to Emily testifying, the court inquired about Emily exercising her Fifth Amendment right. ASA Fix responded, quote, I am not clear on that. Emily's attorney is out in the hallway with her right now. I did attempt to speak briefly with Emily. Her attorney said if was possible if I had those conversations with her when she is on the stand, unquote. This record demonstrates that ASA Fix simply did not have the opportunity to, quote, coerce, unquote, Emily into perjuring herself. According to the record, ASA Fix did not prepare Emily for her trial testimony. Emily refused to speak with ASA Fix after Emily was subpoenaed for trial. ASA Fix's attempts to speak with the witness immediately prior to testifying occurred in the presence of Emily's attorney, a person entrusted with protecting her client from state coercion. As this court has repeatedly stated, dismissal is proper when the original trial record contradicts the defendant's allegations. This trial record is, in this matter, affirmatively refutes defendant's allegations that ASA Fix induced perjury. So you're going to say that without even letting Emily tell you what now Judge Fix made her say. Moreover, even if the record did not contradict Emily's allegations that she perjured herself during her trial testimony, a third stage post-conviction hearing would not be warranted. A, quote, defendant is only entitled to an evidentiary hearing if there is a substantial showing of a reasonable likelihood that the false testimony could have affected the judgment of the jury, unquote. Now they're talking about another case. I'm not reading that. This court also does not condone perjury, yet Emily, like the witness in the case they were talking above, testified only in support of the state's motive and was not the sole source of motive evidence. In fact, Emily's testimony mirrored the testimony of defendant's friends Julia Fields and Maggie Zimmer. As a result, her testimony was not crucial to the state's case, merely helpful. At best, taking defendant's allegations as true, as the court must do at the second stage proceeding, defendant alleges that ASA Fix induced perjury with testimony that did not have a reasonable likelihood of affecting the judgment of the jury. Such allegations are insufficient to meet defendant's burden of demonstrating a substantial deprivation of constitutional rights. The court finds that this claim of prosecutorial misconduct must be dismissed. Big shock, dismissing. She's a judge now. Defendant further alleges ASA Fix, now Judge Fix, induced perjury when she presented Detective Juan Mazarigos to the grand jury. According to defendant, Detective Mazarigos testified to the grand jury that Sean Gale arrived at a barbershop between 8:30 a.m. and 9 a.m. on the morning of the murder. Under defendant's theory, this testimony provided Gale with a false alibi. As the court previously indicated, a conviction must be overturned if there is any reasonable likelihood that false testimony could have affected the judgment of the jury. What affects a trial jury's judgment is the testimony it actually hears and the evidence presented to it. The trial jury never heard this false alibi testimony from Detective Mazarigos. According to the trial record, Detective Mazarigos did not testify regarding Sean Gale's arrival at a barbershop on the day of the murder. Rather, the trial jury heard Sean Gale testify that on the morning of the murder, he slept at his home alone until 9 a.m. and arrived at the barbershop around 10:30 a.m. Taking defendant's allegations as true as the court must, defendant essentially contends that ASA Fix induced perjury with testimony that not only did not have a reasonable likelihood of affecting the judgment of the trial jury, was not even heard by the trial jury. With such reasoning, defendant fails to meet the strict standard of materiality required to advance her claim of inducing perjury to an evidentiary hearing, and dismissal is warranted. Lastly, defendant claims the state coerced defendant's teenage son, Andrew Yang, into giving false testimony, yet Andrew never testified at trial. Whatever statement Andrew provided, even if false, was not a factor in the jury's verdict and is therefore not subject to review in this post-conviction proceeding. Next section is Brady violations. We're now on page 24 of 33. Defendant's petition further alleges that the state failed to disclose evidence in violation of Brady. A Brady claim must show, quote, 1. The undisclosed evidence is favorable to the accused because it is either exculpatory or impeaching. 2. The evidence was suppressed by the state either willfully or inadvertently. And 3. The accused was prejudiced because the evidence is material to guilt or punishment, unquote. Evidence is considered material if there is a reasonable probability the result of the proceeding would have been different had the evidence been disclosed. Blah, 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 talking about other cases. Defendant initially alleges that the state withheld and the jury never heard the recording of a phone call between defendant and Christy Passion, where defendant said she would, quote, make shit up, unquote, to tell police investigators. Yet, in direct contrast to this assertion, the trial record reflects that the state introduced the recording of this phone call as People Exhibits 298 and 299. Defendant also alleges, based on unnotarized affidavit, that the state failed to disclose a cooperation agreement with Passion. However, Passion testified under oath before the jury that no such agreement existed. Because defendant has failed to establish any withheld evidence to support her claims, these Brady violations must be dismissed. Defendant next contends that the state, in violation of Brady, withheld specific exculpatory recordings of telephone conversations between defendant and her parents. In reviewing potentially exculpatory evidence, the trial court must be able to determine whether the proposed evidence favors the defendant. Defendant has not proposed either the recordings themselves or anything else from the state that indicates it recorded and then withheld recordings of the phone calls at issue. Rather, defendant's supporting documentation for this Brady claim includes statements from her father, Larry Morar, her mother, Francine Morar, and 2 charts that purportedly display recorded lengths of various telephone calls. Both Larry and Francine's statements are labeled affidavit. However, neither of them are notarized. Oh, God. An affidavit consists of a statement sworn to before a person who has authority under the law to administer oaths. I'm a notary. Notarization verifies the identity of the person signing the document and ensures that person understands that he subjects himself to penalties of perjury in the statement. Where a defendant's post-conviction counsel is unable to obtain a properly notarized affidavit, the court may dismiss the petition upon the state's motion. Talking about another case. Similar here, the lack of notarization renders both Larry and Francine's statements insufficient evidentiary support for defendant's Brady claim. See, again, this is something to me that, I mean, I guess you could say ineffective assistance of counsel if Jed didn't get these statements notarized, but Larry and Francine absolutely would agree to have it notarized. I'm a notary. Jed's secretary is a notary. Anybody could notarize these things. So instead of just going, we're going to toss this out and you can't use it, I'll notarize it. My stamp's not up here, it's downstairs. I'll notarize it. Piece of cake. Why are you trying to block evidence? So that shows me that you don't care about what actually happened. If you're going to find any excuse to say, nope. I get it if that's the order of doing things, that this has to be a notarized affidavit. I'll notarize it. Even if these statements were notarized, they would not support defendant's allegation. Both statements, nearly identical, describe telephone conversations in which defendant told her parents that she would make up a story that defendant shot Ryder to protect her son, who defendant believed was a suspect. Neither statement identifies the date or time of these calls. Both Larry and Francine state, quote, I know that defendant's phones were subject to overhear orders, yet the above conversation, though recorded, was not produced or provided to the defense, unquote. And would there be cell phone records or telephone records? And yeah, they were taping every conversation Marni had. But you don't have these calls. Whatever. Affidavits containing conclusory statements provide insufficient support for post-conviction claims. Now talking about other cases. Examined in a light most favorable to defendant, Larry and Francine's statements support the portion of defendant's claim that the phone calls occurred. However, the statements conclude that the state recorded these particular telephone calls from defendant simply because overhear orders existed for defendant's phone. The existence of overhear orders, without more, does not demonstrate that the state actually recorded these particular phone calls between defendant and her parents. The conclusory statements from Larry and Francine fail to show that the state recorded and possessed recordings of the calls at issue, much less that the state failed to provide them to the defense as defendant claims. Defendant also supplies two charts, one for Larry Marar and one for Francine Marar, purporting to list her communications with her parents between February 28, 2009 to March 2, 2009. It is unclear why defendant has chosen these dates, since in their unnotarized statements, neither Larry nor Francine specified a date or time when they received the telephone calls at issue. The charts contain no indication of their origin. The charts do appear to identify the date, times, and recorded, presumably by the state, lengths of different telephone calls, but they do not include the content of any of the calls. As a result, it is impossible to determine from these charts whether the state actually recorded telephone calls from defendant with a conversation concerning making up a story about defendant's participation in the murder. Isn't that just so convenient for the state? Because you're telling me Marni talking to her parents on the phone would not be something that they would be listening to and that they would have recorded? Yeah, right. Okay, now talking about other case again. The court granted defendant great leeway for discovery to fully support all of her allegations. Despite this allowance, defendant has not presented any viable evidence of the existence of the recordings she alleges the state made. The Marar statement and charts of recorded calls do not demonstrate that recordings of the alleged exculpatory telephone calls exist. This evidence fails to support her claims that the state recorded specific exculpatory telephone calls to her parents and the state, then withheld those recordings in violation of Brady. As a result, dismissal of this claim is proper. And let me say here too, you're not supposed to put all your eggs in this basket. You're trying to get to an evidentiary hearing where then you will follow up and show them the proof and the evidence of your statements. So to just toss these things without letting Jed show you why these are, again, just shows me that our courts are not about justice and about truth in facts. In her final allegation based on Brady, Defendant contends that the state withheld photographs of the murder scene that her experts in forensic investigations used to conclude the shooter was a foot taller than defendant. Because this claim is so intertwined with defendant's actual innocence claim, the court will address both claims together below. 4. Actual innocence. Defendant's final post-conviction claim is that she is actually innocent in this matter. Illinois law allows relief under the act of a claim of actual innocence based upon newly discovered evidence. A court should grant relief on a claim of actual innocence only if a defendant has presented supporting evidence that is newly discovered, material, non-cumulative, and, more importantly, of such conclusive character as would probably change the result on retrial. At this second stage, as with defendant's constitutional claims, the defendant must make a substantial showing of actual innocence, such that an evidentiary hearing is warranted, and all well-pleaded factual allegations must be taken as true. Evidence is newly discovered if it was discovered after trial and could not have been discovered earlier through the exercise of due diligence. Well, but that exercise of due diligence is ineffective assistance of counsel, which you're trying to say didn't happen. Material means the evidence is relevant and probative of the petitioner's innocence. Non-cumulative evidence adds to the evidence the fact finder heard at trial. Lastly, conclusive means the evidence, when considered along with the trial evidence, would probably lead to a different result on a retrial. A defendant's new evidence must be, quote, so conclusive that it is more likely than not that no reasonable juror would find him guilty beyond a reasonable doubt, unquote. The conclusiveness of the new evidence, quote, is the most important element of actual innocence claim, unquote. The court struggles to articulate defendant's actual innocence reasoning, primarily because defendant repeatedly fails to allege the necessary elements of an actual innocence claim. Initially, defendant contends she is innocent because her trial counsel was ineffective, the state suborned perjury, and other prosecutorial misconduct previously addressed in this order. Although defendant supported one of her suborning perjury arguments with the affidavit of Emily Yang, the court has determined that Emily's affidavit was immaterial. Further, defendant's claims that her experts reviewed trial evidence to conclude that no homemade silencer was used and that the gas station video did not show defendant's rental car fail to support a viable actual innocence claim. An expert's conclusion does not constitute new evidence, yes it does, when that conclusion is based upon evidence that was available prior to trial. No, because see, that would be ineffective assistance of counsel. Sure, it existed if the original attorney had done their due diligence and actually researched these things, but didn't. None of defendant's initial assertions are supported with newly discovered material evidence. Evidence defendant must present to succeed in her actual innocence claim. Accordingly, these contentions are legally insufficient to support defendant's claim of actual innocence and must be dismissed. My God, I'm told this was good today, but so far everything I've read, I'm on page 29, has just been nasty. The defendant also seems to claim that she is innocent because the prosecution failed to investigate other suspects, including Sean Gale. Not only does this argument fail to fit the parameters of an actual innocence claim, but it is also directly refuted by the trial record. The record reflects that the police investigated Gale's dating partner, Monica Karaska, discovering she had an alibi for the time of the murder. The trial record also shows police investigated Sean Gale himself. Police spoke with Gale for 10 hours for 10 hours in the hours after the shooting. Oh my, look at all that hard work, 10 whole hours. They also interviewed Gale's various associates and followed up on their statements. Oh, of course, the Chicago Bears are going to say, he's a great guy. All in all, defendant's basis for this actual innocence claim is legally insufficient, and the court finds dismissal is warranted. And just because Sean Gale made sure to be somewhere public when this crime was committed, it doesn't mean he didn't pay to have it done. Did you investigate that? No. Defendant next claims that she is innocent because she was home at the time of the murder on October 4, 2007. Defendant relies upon trial evidence and testimony to establish she was home about 9:30 p.m. the night before the murder and at home approximately 10 a.m. on the morning of the murder. At the time the murder occurred, about 8 a.m. October 4, 2007, defendant contends she was interacting with her children as they got ready for school. Defendant fails to provide any tenable supporting evidence, newly discovered or otherwise, to demonstrate that she was in fact at home at the time the murder occurred. Her daughter Emily's sworn affidavit makes no reference to Emily interacting with defendant at any time on the day of the murder. And there's a footnote that says defendant provides unnotarized statements from Brandon Yang and Emily Yang relaying interactions with defendant about 7 a.m. October 4, 2007. Yet once again, the lack of notarization renders both these statements insufficient evidentiary support for defendant's claim. So you again are going to toss something out because somebody didn't stamp it. It doesn't change what they're saying. It doesn't mean what they're saying is not factual just because somebody didn't put their stamp on it. I'll go put a stamp on it right now. I am a notary, licensed in Illinois. Defendant next claims innocence because she fabricated her description of the murder in recorded conversations with her friend Christy Passion at a local Denny's restaurant. Defendant alleges she told both Passion and her parents that she would, quote, make shit up, unquote, about her involvement in the murder before the Denny's conversations occurred. Defendant contends that the factual errors in her recorded description support her theory of fabrication. As with her previous claims, defendant fails to present newly discovered non-cumulative evidence in support of this actual innocence claim. At trial, the jury heard the recorded telephone call where defendant tells Passion that they would, quote, make shit up, unquote, to tell the police. As such, this evidence is not new. The evidence of defendant's phone calls telling her parents she would fabricate stories derives from her parents' unnotarized affidavits. Why do we keep saying the same things over and over again? He already said these things, which are insufficient evidentiary support for a post-conviction claim. Moreover, even if the court could consider these affidavits, this evidence is merely cumulative to the Passion recorded call. Further, defendant's claim merely regurgitates a theory defendant presented to the jury at trial. At closing argument, defendant's trial counsel argued, quote, we know truly that Marni Yang is making this up, making her end of it zip. That's what it says. Because there are so many things she is saying on these tapes that have no objective reality, have nothing to do with the actual crime scene, have nothing to do with the actual events occurring, unquote. Defendant's fabrication theory, previously heard by the jury, remains unsupported by any newly discovered non-cumulative evidence. As a result, defendant fails to make a substantial showing of actual innocence with this claim. Lastly, defendant claims she is actually innocent based on her expert's conclusion that the shooter was a foot taller than defendant. To reach their conclusion concerning the height of the shooter, defendant's experts focus on what the autopsy labeled wound B, a bullet wound that entered the victim's front chest just left of center and exited the victim's left arm. And it exited down here. A close review of the experts' multiple reports, memoranda, and affidavits reveal that one photograph of the murder scene from allegedly undeveloped rolls of film assisted in determining the impact site from the bullet that caused wound B. The bullet impact site is one of several factors the experts state they relied upon to determine the height of the shooter. Defendant alleges the undeveloped rolls of film assisted in determining the impact site from the bullet that caused wound B. The bullet impact site is one of several factors the experts state they relied upon to determine the height of the shooter. Oh, I already said that. Defendant alleges the undeveloped rolls of film were withheld from her in violation of Brady. The state contends the defendant was aware of the existence of the undeveloped photographs. It refers to the state's photographic log, Bates stamped and included in the record that lists each of the rolls of film and describes the scene photographed on every exposure on the rolls. To determine whether a Brady violation occurred, the court must find that the photographs were in fact withheld and that they are material. We finally have a win on page 32 of 33. At this second stage of post-conviction proceedings, the law prohibits this court from engaging in any fact-finding. A motion to dismiss assumes the truth of the allegations and supporting documents, eliminating all factual issues from the inquiry, and questions only the legal sufficiency of those allegations, which, if proven at an evidentiary hearing, would entitle petitioner to relief. Our Supreme Court has made clear that claims based upon matters outside the record cannot be resolved at this juncture. Instead, credibility determinations may be made only at a third stage evidentiary hearing, unquote. Deciding whether a Brady violation occurred and addressing the merits of the parties' arguments concerning the height of the shooter are matters outside the record that would require this court to engage in fact-finding of credibility determinations. The law simply does not permit this court to perform these functions at this second stage. As a result, the court must hear and consider relevant evidence to determine whether defendant can establish her claim of actual innocence based on newly discovered evidence concerning the height of the shooter. Accordingly, the issue concerning the height of the shooter will proceed to an evidentiary hearing to consider the evidence and arguments of the parties and thereby determine whether defendant can establish a legal basis entitling her to a new trial. Conclusion. So I've been reading for an hour and 11 minutes now, but these last 3 teeny tiny little paragraphs is really all we needed. But it's still good to have it all. For the reasons stated above, the state's motion to dismiss defendant's post-conviction petition is granted in part and denied in part. It is further ordered that the clerk of this court serve a copy of this order upon defendant. It is further ordered the defendant be notified as follows. You are hereby notified that the court has entered an order, a copy of which is enclosed herewith. You have a right to appeal to the Illinois Appellate Court in the district in which the circuit court is located. If you are indigent, you have a right to a transcript of the record of the post-conviction proceeding and to the appointment of counsel on appeal, both without cost to you. To preserve your right to appeal, you must file a notice of appeal in the trial court within 30 days from the date the order was entered. And it is entered by Judge Christopher R. Stride. So let me go back right now real quick too, because I'm getting... Is it from here? Is it from here? Okay. Because I'm getting Google alerts while I was reading that of news on this case that I'm going to paste this link to this article here. And I'm going to read this article now. This is from Fox 32 Chicago, who was not at the hearing today. Marni Yang conviction. Lake County judge could rule on new evidence. Oh, so this just says, a Lake County judge could rule this week on the admissibility of evidence in the ongoing post-conviction proceedings for Marni Yang. The hearing is scheduled for 1:15 p.m. Thursday and could potentially sway Yang's case. The proceedings stem from a post-conviction petition filed by Yang's attorney, Jed Stone, on October 1, 2019. This petition aims to challenge Yang's 2007 murder conviction of Ronnie Ryder and her unborn child. Ryder, who was romantically involved with former Chicago Bear Sean Gale and 7 months pregnant at the time, was gunned down at her Deerfield home on October 4, 2007. In 2011, a jury deliberated for only 3 hours before convicting Yang of the murders. Prosecutors argued that Yang was motivated by jealousy, as Yang was also romantically involved with Gale. They presented a secretly recorded confession Yang made to a friend as part of their case. Sorry that people are texting me and it keeps going off. Yang is currently serving 2 life sentences for the killings. According to Stone, since the filing of the petition in 2019, a stream of new evidence, experts, and witnesses have allegedly emerged. Despite Stone's assertions, prosecutors maintain that there exists an overwhelming amount of evidence implicating Yang in the crime. In 2020, Yang's lawyers questioned the alibi of Gale, saying his timeline didn't add up. They also requested surveillance tapes from the barbershop where Gale said he was getting a haircut at the time Ryder was murdered. The impending ruling by the Lake County judge will shape the course of Yang's legal battle, with ramifications that could potentially alter the outcome of her conviction. That's the end of that story. And now and I'm just going to delete that because I'm not going to post that one. And now this one is from the Chicago Tribune, which typically you have to, I don't know if I'll be able to read this because they want you to have a paid subscription. I'll share that here because sometimes it lets you, you can watch one or read 2 articles a month or something. Judge allows Marni Yang to argue killer of former bearer's girlfriend was taller. This is the key that unlocks everything. So this guy then had to be, because there were 2 guys that I know from our ABC News and our NBC News here in Chicago, John Garcia and Charlie Wojciechowski, that were there, and they were there with their camera crew. Then there was a guy who was just taking notes, and he was like recording things on his phone. So then I'm going to guess that's who this is on Chicago Tribune, because that comment they said is something that Jed said directly to them. And it was immediately after this, when we were walking out, Jed had called for me and said he wanted me to go downstairs in the lobby where press always waits to then talk to everybody to interview them, and to tell press that he had to go into another murder trial that he was that he's the defense attorney on, and that he would go down there in an hour and would talk to the press. And so while Jed was saying that to me, Charlie Wojciechowski and John Garcia both walked out, and I'm like, well, Jed, you can just tell them right now. And so then Jed really quick said something to them, and one of those is, this is the key that unlocks the door. But okay, let me read you this article. And this one then I will end up sharing since it's after. Marni Yang, who is serving a life sentence for the 2007 murder of a perceived romantic rival, will be able to present evidence suggesting the person who shot the victim was much taller than Yang, a Lake County judge ruled Thursday. Judge Christopher Stride said the evidence can be presented when Yang's post-conviction case advances to the hearing stage. Yang is seeking to overturn her 2011 conviction of the killing of Ronnie Ryder, the pregnant girlfriend of former Chicago Bear Sean Gale, who was shot to death in her Deerfield condominium. And I'm holding this up because I'm 5'6", Marni is 4'9", Ronnie Ryder was 5'9". So Ronnie was 3 inches taller than me. And that first shot, not the B shot that they keep saying, the first shot went in the chest, out by the elbow, in a downward. Her arms aren't up. Her arms are down. It's a downward. And pathologist Cyril Wecht, we have video. We have video of Cyril Wecht, who is given all the information, says that that was the first shot and that the shooter had to be taller. Cyril Wecht, part of JFK assassination, Elvis's death, Whitney Houston, John Benet Ramsey. Cyril Wecht is unknown pathologist. Cyril Wecht says Marni Yang is innocent because what the state is claiming is the first shot is not. In a 33-page ruling published Thursday, the judge dismissed many of Yang's post-conviction claims as not meeting the standard for an evidentiary hearing, but his decision to allow evidence regarding the height of Ryder's killer was greeted by Yang attorney Jed Stone as critical in her bid for a new trial. Quote, "This is the key that unlocks everything," unquote, Stone said after Thursday's hearing. A few minutes earlier, he and Yang exchanged a high five in the courtroom as they read through the judge's order after the hearing. Stride said Yang's contention that she is too short to have shot Ryder is a new factual assertion and therefore something that can be decided only at an evidentiary hearing. Quote, "As a result, this court must hear and consider relevant evidence to determine whether Yang can establish her claim of actual innocence based on newly discovered evidence concerning the height of the shooter," the judge wrote, unquote. Stride dismissed other Yang claims that her trial counsel was ineffective and that prosecutors had engaged in misconduct. Ryder, who was 7 months pregnant with Gail's child, was shot at about 8 a.m. on October 4, 2007, and was found dead in the kitchen of her condo. Yang met Gail, who played on the 1986 Super Bowl championship team, at a 2005 Chicago Bears convention, and they engaged in a relationship, according to authorities. Police contend that Yang killed Ryder out of jealousy. At trial, a friend of Yang's described details of the murder that the friend said Yang had shared with her. The friend also testified that she accompanied Yang as Yang disposed of evidence connected to the slaying. Yang has said she fabricated details because she knew her friend was wearing a recording device. Yang said she wanted to derail police who were looking at her son as a possible suspect in Ryder's murder. Yang was tried in March 2011 and found guilty of 2 counts of first-degree murder. She is serving a life sentence. And they went after her son Andrew a year prior to this time when they were coming back. They went into that 16-year-old boy's school and told people that Andrew murdered somebody. The kid was mortified. And now my husband's pulling in, so now my dogs are barking. And he had a nervous breakdown and had to be hospitalized. And now here they come again. And they tell Christy Passion when they're talking to her that they are going to arrest Andrew. And that's what Christy tells Marni. And then Marni says she's going to make shit up because she doesn't want them harassing her son. Period. So, all right, my husband's home. I'm starving because I haven't eaten yet today. I want dinner. I've been on here for almost an hour and a half. It was hour and a half of driving there, an hour and a half driving back, all that. It's been a crazy long day. So I am going to go. So in a week or so, we will find out what date gets set for her stage 3 evidentiary hearing. And you know I'll be covering it. And any press that I find about this case, I'll be sharing the links here on Justice with Jax. And if we hear anything on any of the other cases, I will come and fill y'all in. All right, I'm out of here.